Hi, I'm Darcel Lobo and I own Dow Law Firm in Normandy Park, and today we're going to talk about Form 17. If you are a seller in Washington State and you are selling residential property, then you may have heard about this form that has to be completed for you to sell the property. It is given to a buyer and it discloses your first-hand knowledge about the property. It's about 5 or 6 pages long, and it covers all the systems of the house, the structure of the house, and what you know about the condition of the home. It goes over electrical questions, plumbing questions, roofing, foundation, insulation, water. It covers a lot. It's a very comprehensive document that you have to complete about the property, so you can provide that to your buyer and let him or her know about the condition of the property. So most of the questions are either yes, no, or I don't know. And if on certain questions you answer yes, it requires you to give an explanation about that. Now, keep in mind that this document is only about your first-hand knowledge. So you're not expected to know what happened before your ownership, or if it's been a vacant property, or if you've never occupied it, maybe it's been a rental property. You may not know everything about the property, and that's okay. You don't have to know everything about the property in order to fill out the form, and that's why there are options for don't know as one of the responses to the form. But what's important about the form is that you are truthful. You have to be honest in disclosing what you actually do know about the property. So the issue that sellers run into is that sometimes they may not be honest about what their knowledge is about the property. And if it's later shown that you did know about it and you were not truthful in your disclosures, you could have some liability to the buyer. Now, everyone has to complete this form, whoever is selling the property in Washington State, with a few exceptions. And one of the biggest exceptions that I deal with in my office is a probate sale. So when someone passes away and they own a home, if probate is opened and the executor is selling the home on behalf of the estate is exempt from having to complete Form 17 because no one in the probate has the first-hand knowledge. The executor does not have first-hand knowledge about the property because it's part of the decedent's estate. And so there is an exception. So if you are selling the property as the executor of a probate estate, then you do not have to complete Form 17, but you want to make sure your contract says specifically that the sale is exempt from Form 17. So very important to keep in mind if you are selling in a probate, you want to ensure your probate attorney is involved in assisting you and reviewing any contracts that are being entered into for the sale of the home to make sure that you don't have any liability beyond what's required under state law. But for most everyone else selling residential property, this form has to be completed. I generally advise my clients when they're the sellers to provide that initially, right off the bat. That way the buyers have that information right away, and we can know sooner rather than later if there's going to be an issue with that Form 17 if the buyer has any concerns about the condition of the property. And that way you have put the buyer on notice in the event there is something wrong with the property and they're having an inspection done on the property, which they usually almost do. Then they have that knowledge beforehand and they can ask their inspector to take a look at it based on what you disclose in the Form 17. You want to make sure the buyer has full disclosure and has the opportunity to review the issue with their inspector. That way it reduces any chances of liability for you because you have fully disclosed, and they also had their own inspector after having that information on your Form 17. And so ensuring that that information is provided sooner rather than later is always my advice to my sellers, is to complete that form, give it to the buyers right away, and then the buyers will sign off on the form as well, saying that they accept the Form 17 and they accept the home with the conditions that you've listed, or they don't accept it and the contract terminates. So as a seller, you'd also want to know that sooner rather than later, is this Form 17 going to be an issue? So if you know before selling the home that there are some issues with the property, that maybe they haven't been fixed or haven't been fixed properly, then you might want to talk with your agent or with your attorney about if you should fix it, what the cost involved is to fix it, and what the return on that, repair may be, to determine if you should truly sell it as is and not make the repairs, or if you should make a few repairs before selling it to maximize the return on that investment for those repairs. So while the sale of the home is an as-is sale, there are some contingencies attached to an as-is sale. You have to make sure that you're being honest with your buyer when you're selling the property. It's not enough to just say, I don't know, if you actually in fact do know. So if you have any questions about your seller disclosure form, certainly talk to your real estate agent if you have one. If you want to talk to an attorney, or if you have an attorney, talk to him or her over your concerns about the seller disclosure form and make sure you're completing it accurately. That's the biggest piece of advice I can give any seller when completing that form, is that while it's a very lengthy form, it's a little bit overwhelming and daunting to think that you have to know everything about the property. You don't. It's only based on your knowledge of the property since your ownership of the home. So hopefully this was helpful. If you need help with buying or selling a home, we'll be happy to assist you. Our number is 206-408-8158. Thank you.